We will first hear Professor David Kretzmer from Hebrew University.
Thank you, Stefan. I think it was not fair for you not to tell me in advance that you'd written your PhD on neutrality. And there's this saying that better keep your mouth closed and let people think you reform than open your mouth and confirm it. And so I'm a bit reluctant, but as I agree with what you said, I can go ahead. I'm going to speak about the implications, the legal implications of the support that the United States and the other NATO states have been giving to Ukraine. And there are a number of questions here. And I must say, advance, unfortunately, I didn't read your doctorate, but in preparing for
It's in German anyway.
it's in German, but I can read it. So I can't speak, but I can read. But I found very helpful, you know, that the main discussions in international law now on the blogosphere. And so I think in advance I should pay credit to people who are unshamedly borrowed from what they write. And one is Kevin John Heller and Mike Schmidt, who've written about these questions. Now, I mean, I can just, can you have the next slide, please? I'm just going to have a few slides. I'm not going to bother you with the whole presentation. The fundamental assumption is exactly what Stefan said. And that is that the Russian invasion of Ukraine, and I think it began in 1914 when they invaded the Crimea. It didn't start in February, but it is clearly an act of aggression in violation of Article 2.4 of the United Nations Charter. And of course, the Security Council could not pass a resolution because of the Russian veto. But instead, we do have a Uniting for Peace resolution of the United Nations General Assembly of the 2nd of March 2022. It was supported by 141 states, and there were only 5 states which voted against, all of them in some way connected with Russia. There were quite a lot of abstentions, but only 5 states were against. And there's very strong language for the General Assembly, and that is it took was, and just take the bottom of it in the strongest terms, the aggression by the Russian Federation against Ukraine in violation of Article 2.4 of the Charter. So it's 100% clear, as Stefan said, it is a clear-cut case. I think that the Russian attempts to provide legal justification for its actions, they do not hold water. As we know, the only basis for a state to use force unilaterally under prevailing international law is when it was subject to an armed attack. Russia is not subject to an armed attack. And clearly, then Ukraine has the right, the inherent right for individual and collective self-defense, and that will become important after the later. Okay, so now what are the legal questions? And the one question is the question that Stefan mentioned, the question of neutrality. So I'm going to speak about that briefly because he said what we have to say, what I intend to say. The second question is the use of force. By replying, by supporting Ukraine, can you say that countries which regard themselves are liable for use of force against Russia? Third question, which is probably the most difficult, is the question of co-belligerency. Can they be regarded as co-belligerent? And we'll see what are the implications of that. The third is, does Russia have the right, as there's an armed conflict, to attack the weapons being brought by third parties into Ukraine? Can they do it in Ukraine? Can they do it out of Ukraine? And the final thing is the violations of HIL. Clearly, the major violations have been by Russia, but there are credible reports that there have been violations by Ukrainian forces in relation to prisoners of war. I don't know how there's much evidence, but they have been. So now what has been the support? And I think it's quite important to see what kind of support we've had, because this becomes an important feature in some of our questions. Slides. The support has been first and foremost the supplying of weapons, but second of all, and this becomes very, very important, supplying of intelligence by the United States especially, but I think by other NATO countries. Then there's the question of not only supplying general intelligence, but supplying information on possible targets from Ukrainian forces. And there were claims in the press, but again, these are not things that I have the possibility of examining from a factual point of view. that the United States was supplying more specific intelligence information on possible targets. The claim was that the Ukrainians killed 12 generals of the Russian forces. It was based on information provided by the United States. And then, of course, we have the issue of the training of the military. The United States has been training the military of Ukraine, so has the United Kingdom. And then there's economic aid, which in my mind does not raise an important question. So now let's see let's start with the question of neutrality. And here we have two conventions of 1907. One is the Convention on the Rights and Duties of Neutral States in War on Land, and the other is the Hague Convention, it's number 13, on the rights and duties of neutral states in naval. And the interesting thing here is that the United States, Germany, Ukraine, which joined recently, and Russia are all parties to these conventions. The United Kingdom is not a party to these conventions. So the question is, have the states, by supplying weapons to one of the parties, violated the duties under this treaty? Now, there's a question that you've mentioned of whether these rules have become part of customary international law. And clearly, as I'm going to mention, when these duties come into conflict with other duties which may arise under the UN Charter, the duties under the UN Charter are going to prevail. But still, the question is there a violation of neutrality being with this? And the argument, I don't think, could be made under customary international law. But Ukraine, by joining these treaties very late in this thing, when was it, 2015, after the Russian invasion of Crimea, has given credits to the notion that these treaties are still valid and that they have some kind of importance, because there were people who said, well, these treaties really ascribe to it, they're no longer enforced, but like your actions in a way have supported the view that the treaties are still valid. But here we come. So it would be clear that if we were just looking at these treaties by themselves, the parties to the treaties, the United States and Germany, have violated their duty of neutrality in this conflict. Now, it's true that the treaty relating to war on land does not specifically say that providing weapons to one party is a violation, but it does say that if a state does not prevent private individuals providing weapons, then it is not violating its duties. So the implication is that if it is providing weapons, it does do so. But as Stefan knows better than I, we now have the notion of qualified neutrality, which we must have because of the clear provision in the United Nations Charter, which is now part of customary international law. It's part of, in fact, this cogence against the use of force. That certainly the notion of qualified neutrality means that states may give aid to a victim of aggression without violating the rules on neutrality. So they have a duty. If the party is subject to aggression, they have a duty to come to the aid of that party was victim of a serious violation of international law, and that duty overrides their duty under the neutrality. But in all events, the one thing that we have to remember that even if we take the line, and I think Stefan does not take the line given why that these states have violated the duty of neutrality, that doesn't justify use of force against them. The maximum that Russia could do was to take countermeasures, say, like cutting off the oil to Germany, which more or less is done already. So I don't think that the neutrality is really a big issue. Now, what about the support for one party to a conflict? Does this involve use of force against the other party? Now, this would seem to be a non-issue and a non-issue. Why do you raise this question? The problem is judgment of the International Court of Justice in the Nicaragua case. And that is our problem, because in that case, the United States was supplying weapons and training to the Contras for use against Nicaragua. Nicaragua brought a case against the United States, and the International Court of Justice said that by supplying weapons and training to the Contras, the United States was in violation of its duty not to use force against Nicaragua. Now, to what extent is this valid here? I don't think it is, but let me say why. First of all, that case, they also decided that the actions of the United States comprised interference in the internal affairs of another state. So that is not the case here, because the United States supported. That case involved a non-international armed conflict, and this is an international armed conflict. But I think more important than that is the notion of collective self-defense. And Ukraine certainly has the right not only to individual self-defense, it could have invited, as it more or less did by saying, why don't you apply a no-fly zone? It more or less invited the other states not only to supply them with arms, but to come to their help, which would have been legal, because it's collective self-defense. And if they have the right to self-defense, they collective self-defense, then other parties, of course, can join them. So if the United States or these other countries could have come to the military aid of Ukraine under the notion of collective self-defense without violating the use of force, then it seems pretty obvious that if they're doing less than that and supplying arms or training, it does not involve use of force against Russia. But anything else, if we look at the draft articles of state responsibility, basically part of customary international law, according to the International Court of Justice, we see that the wrongfulness of an act of a state is precluded if the act constitutes a lawful measure of self-defense taken in conformity with the Charter of the United Nations. So that even if you could say, well, the Nicaragua thing is going to apply here, but because it was taken as a lawful act of self-defense, the collective self-defense of Ukraine, it does not involve violation of use of force. Now, the more serious question in my mind, although you're probably right, Stephen, that this is a good question for international lawyers, it must not really have that much practical importance. And that is the question of co-belligerence. We have an international armed conflict between Russia and Ukraine. The parties to that conflict are, at the moment, Russia and Ukraine. And in the relationships between Russia and Ukraine, the law of armed conflict, or some people like to call it international humanitarian law, applies. Any party which is not, any state which is not a party to that, their relationships with Russia is not regulated by the law of armed conflict. And so the question is, are some of these states, all of these states, co-belligerents with the United with Ukraine by virtue of the support that they've given to Ukraine? And if so, then the law of armed conflict would apply between them and Russia, which would have quite a lot of legal consequences. For instance, it would give the Russians the right even to attack them, especially when they're supplying arms in one of the countries which is parties are co-belligerent. For instance, if Germany had become a co-belligerent, I don't think there's enough information for that. But then the Russians would be entitled to go and bomb the weapons in Germany. Now, this is a different question from the question of neutrality, because it's clear that, as we've said, the violation of neutrality does not make the country which has violated neutrality a party to the conflict. There's other rules. Now, the question, and it's a difficult question, what makes a country a co-belligerent? And it seems to me that there's a close connection between this question and the question which is concerned the Israeli Supreme Court, and of course concerned the International Committee of the Red Cross, because under international humanitarian law, a civilian is immune from being attacked by a party to a conflict unless at such time as he or she takes a direct part in its activities. So we have the notion of a direct path in hostilities. And it seems to me that that may not necessarily be the only basis for making a state a co-belligerent, but certainly if members of the armed forces or that state in an official capacity is taking a direct part in hostilities, it seems to be that it will become co-belligerent. So now the question is, well, these acts of support by the United States and the other NATO countries, do they involve direct participation in hostilities? Now it's clear that supplying of weapons as such is not direct participation in hostilities. That is 100% clear. When we come down to intelligence information, and especially target information, the issue becomes much more problematic. Now, the general notion is that we have to make a distinction between providing general intelligence and providing specific intelligence that can be used on the battleground. If I'm providing intelligence that is used on the battleground, then I become a co-belligerent. And so it does seem to me that as far as the United States go, if they have been supplying intelligence to Ukraine about specific targets which they can target in their military activities, the United States becomes a co-belligerent. That implies. Now, I don't think that Russia, especially as it stands at the moment, militarily, of its recent defeats, is about to take military action in the United States and commit suicide. But I'm talking from a legal point of view, and I'm not addressing the political issue. There's another issue, and that is the training of forces. Now, training forces as such does not make you take a direct part in hostilities. But if you're training them for specific military action, say, you're going to tomorrow attack the Russian forces in a certain part of the area, let's train you for this and decide how you're going to do it. That is a much more difficult question that could be a direct participation. The ICLC, in its very important document, its guidance on direct participation in hostilities, regards that supplying specific intelligence information which can be used on the battleground as a clear case of direct participation. Okay, we're nearing. Okay, the next question is, even if they're not a co-belligerent, I don't think Germany is a co-belligerent. I don't think that the kind of support that Germany has supplied, as far as I know, and of course it's still based on the New York Times, it's not based on any specific information, Ambassador may have other information which you can't reveal. I do not have any secret information. But even assuming that the countries are not co-belligerent, so they're supplying weapons. Now, at what stage, if at all, can Russia then attack those weapons before they get into Ukrainian hands? It's clear that once they're in the hands of the Ukrainian army, it's a military object they can be attacked. Now, it does seem to most commentators that is, as long as once the weapons are in Ukrainian territory, that given the notion, as we know, what are military objects, those objects which by their nature, location, purpose, make an effective contribution to military action and whose total or partial destruction offers a definite military advantage. So if we are supplying arms to Ukraine with a definite purpose that they're going to be used against the Russian forces, they become a military target, and certainly on Ukrainian territory, they could be attacked. Now, could they be attacked somewhere else? Well, then you have to just update on the question. Certainly they couldn't attack a target on German territory because Germany is not a party to the conflict. But on the open sea, I don't know what you would say, Stefan. I think that there could be a strong argument that if the weapons are being shipped even by a plane flying over the sea, the Russians could target this. Finally, let's say two other questions. The questions are the violations of IHL. Now, clearly, most reports have spoken about gross violations of IHL by the Russians. But there is some evidence that Ukrainian forces have committed some violations too, especially in relation to Russian prisoners. And then the question is, well, what about the states which have supplied weapons or other support for the Ukrainians? Could they be held liable for these violations? And once again, we come back to Nicaragua example. But this example is going to help these states. Because in Nicaragua's case, the court said as follows. They wanted the argument of Nicaragua was that by supplying arms to the Contras, which were certainly liable for gross violations of IHL, the United States was liable as well. And this is what the International Court of Justice said. In this conduct to give rise to legal responsibility of the United States, it would in principle have to be proved that that state had effective control of the military or paramilitary operations in the course of which the alleged violations were committed. And so it said the United States is not liable for the violations by the Contras. It seems to me that this clearly the United States does not have direct or even indirect control over the Ukrainian forces. And so even if these reports are not credible that the Ukrainian forces have committed certain violations of IHL, certainly the United States or even other countries which will co-military assurance would not be liable. That's all I have to say. Thank you.
The question is following. First of all, Ukraine is having pleasure sharing the intelligence information not just with the states. You will be surprised with how many states are providing it for us. But in the current stage of war, don't you think it's legitimate that during the wartime you will not expect somebody to provide you the weather forecast for tomorrow, but you need this intelligence in order to find the targets, in order to make it helpful for you to be successful in the warfield?
Well, I think we have to make a distinction. I'm not saying that it's unlawful for the United States or for these countries to supply this evidence. As I said, by doing so, because of the clear inherent right of the Ukraine to collective self-defense, it's perfectly legal for them to do something. As you know, there's a distinction between the use ad venom and the use envelope question. So as far as use ad venom goes, they're not violating use ad venom by supplying any intelligence information to the Ukrainians. I would say even if they get them information that Putin is in Ukraine tomorrow morning and they can get him out, it would not be, although I'm not sure that he's a lawful target, let us say the Russian chief of staff or whoever it happens to be. So they wouldn't be violating their duties, but that's not the question that I asked. The question is, do they then become co-belligerents with the implication? That's a totally different issue.
So, very interesting, thank you, fascinating. But I was wondering to what extent your analysis also goes the other way. So, for example, suppose Ukraine now says, Iran now supplies those drones, and I happen to know some intelligence services allow me to know when the air cargo with those drones arrives anywhere, including to Russia. I can target that as Ukraine, right?
I don't think there would be any problem.
Just saying, the symmetry principle goes
the other way. It would work the other way, because in use adverbal, what we are doing, and of course it's been called into question now, but we are divorcing this from the use adverbal question. So now we have an armed conflict between Russia and Ukraine, and the law of armed conflict applies, and this is part of the law of armed conflict. Yeah, I don't think that Iran would become a co-belligerent just by supplying drones to Russia, the way as that I don't think that by supplying weapons to Ukraine, Germany is a co-belligerent. But certainly, once these drones get to Russia, it's a perfectly
even before they get to Russia.
Well, it don't depend where.
In the high airs, somewhere above the high seas, in the high air.
If it's above a certain country, you know, that's right. Sovereignty goes up to the sky, so it could be a violation of their sovereignty. But let's assume that they're in over the sea. Yes, if you know that the purpose is for use against Ukraine.
The Iranian drones are only for you.
Yeah, okay, so yes, I think the same.
Just a follow-up question. With respect to that, assuming you're already a co-belligerent, right? Assuming a certain country is already a co-belligerent, as you heard, because it's a prize, do you think there's a distinction between co-belligerency by supplying the information and then a Ukrainian missile shoots down the plane, or the co-belligerent state shoots the plane down, etc.?
But you're co-belligerent. All the rules apply to you. Whatever Ukraine can do, you can do. Whatever they can do to Ukraine, they can do to you.
So what I'm saying is your analysis then suggests that once you pass the certain threshold of supplying the targeted information, you might as well go all in and say, okay, I shoot down the plane.
But they still have an arguable kind. They still want to retain an arguable thing that they're not really co-belligerent.
Right.
So you're not going to make it too blatant so that you leave yourself leeway to say, well, we only supply general information. It's not clear. If they were really look, the whole question came over the no-flies. Okay, Ukraine said, stop the Russian planes flying over Ukraine. Now, it seems to be a sensible thing, but they all knew that if they do that, then they're involved in the argument. Then it would be a nuclear conflagration.
Right.
Yeah, so I've got a part that, so it's a partly theoretical question, I think, in the context of this particular topic, but I think it is relevant or interesting in the context of what the ambassador was saying earlier about Russia's place in the Security Council and veto, right? Because the other part of the collective self-defense right in Article 51 is that you were supposed to exercise the individual collective potentially self-defense unless you inform the Security Council, then the Security Council is supposed to take measures that are necessary to maintain international peace and security. Now, does that mean in a situation where the aggressor is a country that would never allow the Security Council to take those measures because we would block them, then essentially the right to collective self-defense is indefinite. So it lasts until and unless the conflict ends. Because often, like if I'm thinking back to Iraq, one of the debates around Iraq was whether there is still a right to collective self-defense at the time of the attack in January.
As long as the country is still defending itself. And it says until the Security Council takes such measures, if the Security Council is deadlocked and they can't take such measures, then the tool hasn't arrived. And so you go on with collective self-defense.
Yeah.
Seems to be clear. The question is, what about the United Defense Resolution, which I'm not sure about that. That's checking.
Thank you, sir. That's great. Two questions, practical questions. I'm a journalist, not an academic. One, targeting aside, and by the way, I'm an American citizen. I'm all for it. I'm totally in favor of targeting. That's great. But what if it's even actually more than that? What if, as reports are correct, that the Pentagon is actually straight up planning the operations and engaging in straight up planning with Ukrainian general staff? Is that already co-belligerency or not? Okay. And my secondary question is actually based on a real, on the most creative idea I've seen that any of my colleagues propose. There was a lot of interest, as you probably know, in transferring warplanes to the Ukrainians. It's actually very difficult for all sorts of reasons, but one of the main reasons was, to make it difficult, was to avoid complicity in handing over actual warplanes to the Ukrainians. Actually, also very difficult, just in terms of trucking them over. How do you actually get a warplane? And so, the most interesting proposition that I saw in any of my colleagues' white papers. And this was checked out with the Slovakian government. The Slovakian government proposed changing its own constitution to hand over a kilometer of its own land to the Ukrainian government, self-annexing a couple of kilometers of airstrip on the Ukrainian-Slovakian border through the Slovakian constitution, just handing over its own territory to the Ukrainian government, putting planes on the border, and then changing the Slovakian constitution to hand over its own territory to the Ukrainians. And there are planes on our territory. Where do they come from? If they do that, is that a violation of co-belligerency?
I don't think you can get around these questions just by all these other tricks. And now I would say as follows, that if, and it's a big if supplying warplanes to the Ukraine would be regarded as a direct participation in the hostilities and making the country which supplied them co-belligerent, the way you do it is not going to be very relevant in my mind. But as I said, up to now, supplying weapons as such has not been regarded as sufficient. However, if Ukraine said, listen, tomorrow morning we need warplanes for specific military action, and now on the we are now on the offensive and we can get the Russians out of the whole of the eastern Ukraine, and we need planes for this specific thing, give us the planes, and they supplied it, then you would have a much stronger case to start.
Thank you.
One practical issue, very, very short one. Now it's a big debate about the issue whether to provide Ukraine with the long-range and medium-range missiles, because of arguably they would shot into the Russian territory. But it was a few successful attacks on the Crimean air bases, as you know, which belongs to Ukraine, regardless whether the Russia changed its own internal legislation saying that now it's a part of Russia. Absolutely. But the question is that we've been attacked from the Russian territory and territory of Belarus quite substantially from the airports. So if you shoot on those military objects outside of the territory of Ukraine,
it's perfectly clear. Once you're a body, it's clear that Belarus is a global country.
Absolutely.
I didn't mention that, but by allowing the Russian forces to invade the Ukraine from Belarus, they became co-belligerents. Now, once that is the case, then you just go back to the ordinary laws of armed conflict. And if it's a legitimate military target of the other party, and it's in territory of a party to the conflict, whether it be Russia or Ukraine or Belarus, it's perfectly lawful for Ukraine to do it. Now, if it's lawful for Ukraine to do it, it would be lawful for any belligerent. It would also be lawful for you to use weapons which have been supplied by another country. But if you want to do it politically or military, that's a question which I have no expertise on.
It's beyond legal questions.
That's nothing to do with me. I can't even attempt to answer such a question. But you ask a legal question, it's quite clearly. I mean, from a legal point of view, if you thought that you could hit the Russian command sitting in Moscow, you could do it.
I was interested by your relatively expansive reliance on the direct participation in hostilities doctrine. And I think that there may be possible questionable aspect of it, which is that under this doctrine, which is normally regarded towards individual non-state actors, not states as such, whoever becomes targetable is that individual or non-state actor that is directly participating, and not their entire, combatant population. And so there is a difference, a very big difference between saying that particular American, German, or other individuals are directly participating into saying that the United States or Germany as such have become co-belligerents. So there was,
I agree with you, Itamar, that it's a different question. And I'm not saying that if one American was directly participating in hostilities against Russia, then the United States would become a party. What I was saying that we have what seemingly would be the same criterion for deciding. Is the state itself directly participating in the hostilities of the Ukraine against Russia? That is the question which I pose. And I think that one can draw, and I agree with you, it's a different kind of thing. Now, the extent, but if the country in an official way, it's not one individual, it's on behalf of the country itself, decided by the executive branch of that country, is doing acts which involve direct participation, it seems to me that the parallels is valid. know if you agree.
No, I would agree. Usually I would have said as soon as members of the armed forces of the other state show up on the battlefield, and you are part of the conflict.
If I may push back gently, just to say, I think the test with regard to direct participation in hostilities is a factual test. What this armed person is doing actually in order to contribute. And with regard to a state, there's also a test with regard to, as you said, the decision making of the executive branch. And it's a different
but it's still a factual question. It's a factual question. And that's why I say I don't know. I don't know what intelligence supply. That's a factual question. So I have to know.
So I really would say intelligence and military training, because you have often cases where military trainers go with the troops in the battle.
Well, listen, I don't think
then you are again.
Yeah, but I don't think that this happens. They're not doing that here. They're training them in Germany or in Britain, from what I saw. In the United States, they are training them in Germany.
So I was not assuming that it's done. It's simply they are the red lines. Where,
That's correct for the Americans and the Brits. It's not correct for the Poles, the Balts. The Americans wrapped up the CIA and the State Department program for training before the war started, just because of this legal reason. And there are no more CIA trainers. The program's been, but the Poles and the Balts and the Lithuanians do have military trainers, special forces training on Ukrainian territory.
Yeah, but I don't think the point is whether it's on Ukrainian territory.
Okay.
Whether even if they're on your training territory, but they're not actually taking part in the fighting, they're training them or not on the battlefield. So it doesn't matter whether they're doing it in Ukraine or in Germany.
Okay, go ahead. Thank you.
So, like Peter Mark, I feel a bit uncomfortable with the application of the DPH test here to co-belligerency. For example, being part of the ICRC guide is you have to be part of the conflict in order to qualify as another condition. So it's a kind of circular test. But what I want to say is that there is kind of a state practice over the years, which is the real question is if that state would be a party to the conflict. And over the years, we have seen there's a lot of state practice, including Russian advisors advising the Egyptians here and all over the world, giving intelligence support and arms support during wartime. I think there's a body of state practice here that can help more directly as to the question if the state is a party to the conflict, becomes a party to the conflict. Before, and I agree with you, it's very tempting to go to the DPH test because of the at the end of it, you try to find a remoteness of assistance here that will will cross the barrier. And the DPH test itself is drawn in a very careful way, in order to keep those civilians outside the circle, and the state operates in different ways. So although I understand the remoteness, the need for remoteness here, that's what you're looking for. I would look first in the history that we already got during the last decades.
Look, I accept all the criticism of resorting to the direct participation. I admit that it's a jump, okay. But I do not accept your argument of state practice because we've never judged on that whether there is really co-belligerency. So the fact that you'd had a lot of state practice, but it was never asked whether they co-belligerents, were the Russians helping the Egyptians co-belligerents, it never arose because Israel was not about to attack Russia. Okay, so the last thing that Israel wanted to say in that kind of situation is that they're co-belligerents. It would probably prefer to say they're not co-belligerents in order to not have created an armed conflict with Russia. And that there are political factors here involved. So I'm not sure that you could learn anything from state practice. All you could say is that in many cases, states have been involved in helping one side to an armed conflict, but they never were judged of whether they became a co-belligerent or not. So what can we learn from it? So I'm suggesting that the issue is there may be other parameters. I'm not saying that direct participation is the only. You may find other parameters to decide even if there was not direct participation, yes, but I think direct participation of itself is sufficient. Thank you.
Thank you for that.